Good afternoon, Namaskar, Sat Sri Akal, Vanakkam to one and all. I welcome the esteemed panelists and the viewers who have joined for the webinar on this important topic. We have a very distinguished panel from different walks of life, politicians, ex-Chief Election Commissioner of the Election Commission of India, advocates, and representatives from the civil society. This event is an opportunity for us to add impetus and synergy to our work by bringing together all stakeholders. Since some people have asked why there is no representative from the ruling party, I would like to place on record that we had contacted 4 persons from the BJP, out of which 3 declined and 1 did not respond at all. Since this is an important subject which affects all political parties and the citizens of the country, it would have been nice if they had also participated, but they must be having certain reasons. Just to refresh the minds of the panelists and their viewers, I will once again share the focus points of the webinar with a request that the panelists give their views on the points specifically. Nandini, can you please show that? So the first focus point is curbing the rising number of legislators with criminal cases. Who will bell the cat, executive or the judiciary? Does repeated election of tainted politicians adversely affect good governance? Is the Indian voter unaffected by the tainted background of politicians? Lifetime ban or disqualification for 10 to 15 years for convicted politicians, which is appropriate. Slew of Supreme Court judgments, such as fast-track courts, trials to be completed within a year, publication of criminal cases, details by candidates and political parties in the media, etc., as also the recommendations of various committees, commissions, etc., have been unable to bring about reform. Is there a way forward, or will the voters or citizens remain captive of the current duplicitous system, wherein the rules of the game are different for the politicians and the common citizens? To set the context, I will show you a few slides so that we are all aware of the present state of MPs and MLAs with criminal cases and how the numbers are steadily rising over the years. Nandini, can you please show the slides? So as you see this one, this gives the details of the candidates from the Lok Sabha of 2004 right up till the latest Lok Sabha. And if you see in 2004, the figure or the percentage of candidates with criminal cases was 12% and with serious criminal cases was 7%. In 2009, it rose to 15% and 8% serious criminal cases. In 14, it rose to 17% with declared criminal cases and 11% with serious criminal cases. In 2019, it rose to 19% and 13% candidates with serious criminal cases. And in 2024, it has risen to 20% and 14% candidates with serious criminal cases. The same thing is also represented in the bar chart in the lower part of the slide. Next, please. If we were to talk about the party-wise percentage of candidates with declared criminal cases, I have just taken some of the important parties because the national parties, as you are aware, kept changing. Like Aam Aadmi Party wasn't there at all and TMC was removed. So I just taken this as a sample. So if you see for Congress, it has risen from 2009, where it was 27% to 44% in 2024. For BJP, it has risen from 27% to 43% in 2024. For BSP or Baspa, from 22%, it has come down to 13%. And for CPIM, from 25% In 2009, it has risen to 63%. And the slide, which is on the lower half, it gives the details of the MPs with declared criminal cases from the general elections 2004 to 2024. So in 2004, the percentage of MPs with criminal cases was 24%, and with serious criminal cases was 11%. In 2009, it rose to 30% and 14%. In 2014, it rose to 34% and 21%. And in 2019, it rose to 43% and 29% with serious criminal cases. And in 24, the present lot, it is 46% with criminal cases and 31% with serious criminal cases. Okay, next, please. So this is the same thing represented in a bar chart. We can go to the next slide, please.
Jonathan, I can't see the PPT. Just for your information, otherwise you carry on. If you can settle it, it will be good. Otherwise,
okay. Nandini, can you just see what is? I hope the others are able to see it.
Yes, we can see it, I guess.
Okay. All right. Okay. Next slide, please. Neha. We recently, just about a week back, published the report of analysis of all the MLAs from 28 states and 3 union territories of India. So the total MLAs were analyzed was 4,092 out of 4,123. 45% had criminal cases and 29% MLAs had serious criminal cases. Next slide, please. Party-wise percentage. Again, I have taken a few of the major parties. So if you see, TDP, 86% means MLAs with criminal cases, and 61 means percentage of MLAs with serious criminal cases. So the left bar chart is serious criminal cases, and the right one is serious criminal cases. In case of DMK, it is 74% and 32%. In case of SP, SAPA, 62% and 44%. And Aam Aadmi Party, 56% and 28%. Congress, 52% and 30%. And AITC, Trinamool, 41% and 34%. And BJP is 39% with criminal cases and 26% with serious criminal cases. Now, since BJP has the largest number of MLAs, then total number of MLAs analyzed is 1653, which is more than the number of MLAs of all the other parties shown in this chart combined together. Now, having seen this, now let me get down to the thing. I will request all panelists to kindly restrict their views to about 12 minutes or so. And in the end, we'll have a question and answer session. Viewers are requested to post their questions on chat, and questions will be displayed by our team on the ticker tape. Since the parliament session is going on, we are thankful to Sri Gogoi for having spared the time and squeezed out a little time to be part of this webinar and share his view. Since he has to leave early, I will introduce him to the audience before I request him to speak. As you all know, Sri Gaurav Gogoi is a member of the parliament and deputy leader of the Indian National Congress in Lok Sabha. He is member of the parliament representing the Kaliabor constituency of Assam. And prior to joining politics, he worked in the development and non-profit space for 10 years. After graduating from Indraprastha University in engineering, he worked in a non-profit organization which sought to impact social justice through youth citizenship action. After 4 years of working in rural India, he went to pursue Masters in Public Administration at New York University. And during his stint in the US, he worked as a policy aide at the Permanent Mission of India to the United States. As I mentioned, Mr. Gogoi, if you have time, we will ask the audience to put their questions to you before you leave, if that is fine with you. And I'll request you to now kindly share your views. Thank you.
Thank you, Major Verma, and thank you to the Association of Democratic Reforms for having me here. I again apologize that I have to leave soon because, as you said, the Parliament is in session, there are committee meetings. But this is a subject that I have engaged with at many times in the past. Um, and therefore, I wanted to be part of this webinar, both to share my experiences as someone who is been thinking on this issue, but is one of the stakeholders, which is the political party in my particular case. So I really was interested to take part in this seminar and therefore hear from other stakeholders, whether it's public, civil society, election commission, or the judiciary. My view when I first was engaging with this subject, when I was in the civil society, was that they should be, this is a very serious issue, which is that the number of people with criminal records and severe criminal cases who are joining the field of politics and are contesting elections and are winning elections is a very serious issue. And there are many issues related to electoral reform, especially in India. Within all the issues that come under electoral reform, this is one of those sub issues which are very important. That is something that I always felt. But then, as I engaged in politics, got more active in politics, saw what do people keep in mind when voting. It is unfortunate that I realize that people are not keeping in mind, the voter in India is not keeping in mind the criminal antecedents of a person while voting. Now, this is not a judgment call, and I'm not making an opinion, but I'm just stating my experiences, albeit it is anecdotal experiences. But largely, even though when you mentioned that the number of people with criminal cases are rising and every political party has these candidates, I think if you analyze the winnability or how many times have they won, in many cases it might seem that they are winning. So it is not the criminal cases and the criminal past right now is not a deterrent in the voter's mind. And I think that is something that we have to engage with voters, for which one of the first things we have to do, which is to raise awareness, which is to make the information that you have shared in your slide that much more publicly available. People have the right to know the background of the candidates, and they have the right to know, they have the right that this information should be accessible. It should, um, it should not just be on a website. The, the citizens should be able to access this information much more easily, at the click of their finger or the tap of the finger. Many of this information is already there in the election affidavit that is filed by the candidates. But I'm not sure if the voter in my constituency is able to access my affidavit and is able to go through those sections very easily in a user-friendly format. In that affidavit, as a candidate who just contested Lok Sabha, I file in the details of my income, I file the details of my any cases that might be against me, I file my social media properties, I file details related to my educational and professional background. So all of this information I'm filing legally. But does my voter, is he aware? Can they access it? Because the only time this information becomes public is when the media chooses to write about it. That's the only time we know how much wealth a candidate has, or how much wealth has a candidate managed to enhanced over the last 5-6 years, or what are the professional background, or what are criminal cases. That media story, if it gets published, is right now one way that the information reaches the voter. So I think that's something that we need to think about. And political parties respond to public pressure. If the public in Delhi today are pressurizing on air pollution, then the political parties, be it opposition or ruling, they will respond to that pressure. It's a pull. You have to pull the attention of the political class, and you have to put that pressure that, listen, this is a serious issue. Safety of women in public spaces is a serious issue. Air pollution is a serious issue. Education, sewage, drainage is a serious issue. And amongst the plethora of issues that exist, along with unemployment and inflation, so is the issue of criminal people with criminal cases entering politics. So I think and therefore, how do you mobilize the public? A, to create awareness, to increase their awareness. B, to channelize their energies, to put pressure, to signal to political parties that we will punish through our vote if we find that you're indulging in such candidates, and we will reward you. We will reward you if you choose a cleaner candidate, or a candidate with no criminal cases. So, I in my own experience, I know of a state in North India where one of the candidates had a criminal case because that candidate had physically beaten up and assaulted a government officer. Now, at that time, even though there was no public pressure on the political party to change the candidate, it was in that particular case of which I am aware of, it was the call of the political leadership. The political leadership at that point said, listen, even though there is no public pressure, we feel that we should not have such a person on our ticket representing our symbol. And then they took a call at a high level meeting that we will deny the opportunity to this person to contest. But all of that decision making was in house. It was at the very top level, at a very senior level, but it was done very quietly. It was done very discreetly. So the other case, when I'm saying where we can engage with this issue, is at the issue of political leadership. And we tell them that this is something that is important. This was something that will show you in a good stead. Now, the pressure that we have these days on representation is on more women. We're talking about more women representatives coming in the Vidhan Sabha and and on the Lok Sabha. So, but many parties, they themselves, before the women's reservation bill had come, many parties, they themselves, because of the philosophy of their political leadership, said that we want to promote more women, we want to promote more youth, and therefore we have to. That's a decision that we will take. So here, there was no role of the Election Commission, no role of a law passed by Parliament, no role of the public, but political leadership, they themselves decided this. So, these are two aspects that I wanted to place in my opening statement. One, that our public punishing or rewarding basis the criminal antecedents of a candidate. B, uh, our political leadership, how can they be more sensitized to think on this issue, and what positive reinforcement can be given for behavior or for decisions that we like. Other than that, if I just carefully, if I, from a more academic point of view, if the public has the right to choose whoever they want as their representative, then can we deny an Indian citizen the right to contest? If the most, purely as an academic discussion, if an Indian convict has the right to appeal to the final stage, he doesn't lose the right to appeal. He or she doesn't lose the right to legal representation. Then an Indian citizen, on the basis of his conviction, should he lose the right to be a public representative? it's an academic question that we can think about, because I'm not aware of any major democracy in terms of its size and its scale having uh, uh, any legislation around lifetime bans. In fact, I know the opposite, that many people, like in India, in other major democracies also, people have served time in jail, and they have been severely convicted, and yet they go on uh, to 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 take part. That doesn't bar them from taking part in the electoral process. So, nonetheless, it's, in for India, I think this is a very important subject that we should continue to engage on. We should continue to push the boundaries, find ways of making it, of raising the bar for the kind of people that get into electoral politics, reward uh, decisions of political parties that are akin to what we are talking about. At the same time, raise public awareness, make this information. ADR is doing brilliant work, but have other, the statewide chapters or vernacular versions of ADR doing this work much more proactively, and allowing the citizenry also to engage this issue and voice their concerns in a much more organized manner. So with that, I'll just thought I lay out, what my position on this topic currently is, and thank you for this opportunity.
Thank you, Mr. Gogoi, for your views. I just have a comment. It appears that, specifically you have answered some of the questions which the focus points were made out for. But you haven't answered the thing about, there have been so many Supreme Court judgments. And the first question is, who will bell the cat, executive or judiciary? I specifically didn't mention political parties because the political parties do not want to do it. So you have sort of put the onus on the citizens and the voters to do it. And you also mentioned that criminality somehow doesn't form a very important part in the decision of a voter. So is it going to continue like this? And the answer, and this question about, does this affect good governance? If you could kindly answer. Thank you.
No, I did not only restrict it to citizens' engagement. I did talk about political leadership, that political parties have a role to play in this. I did give an example of which I was part of, in which my political party denied a ticket to a person merely, because of his criminal record, despite there being no adverse remarks in public. But the political leadership at that time, in that case, did take its call. So I do place the emphasis on political parties themselves. But if I were to crystal gaze in this particular context, I could, look at a foreseeable scenario in which the judiciary calls upon the election commission to think on this issue, and therefore election commission, in response to a Supreme Court request, thinks deeply and comes up with language that can be taken as a reform. Thank you. I think you're on mute.
I would just like to respond as far as what ADR is doing. Like you mentioned correctly, that the voter needs to be more informed and he can take a choice after, seeing the details of the candidates. We are doing our best. We put out these reports, and by the way, most of 95% of the media reports are based on ADR reports only, wherein we give out all these details. As also, myneta.info is a very popular site and lakhs of people see it during elections, before elections. And the third thing is, we also have an app, myneta app, on which at the click of this thing, you can see all the details. So we do publicize all this, and we are very, on the social media, we do all this. And of course, with limited resources and all, we have a limited reach, but we are trying our best. So, Nandini, there's one question I think for Mr. Gaurav before we let him go. Yeah. So this is the question from Afreen Siddiqui Sherwani. She is from UNDP. A question is, being from the development sector and being deputy leader of the INC, what are some of the ideas you can or want to introduce just as at party level, not waiting for judicial reforms morally, voluntarily?
Thank you, Afreen. I think, first of all, as I said, that I look at this issue under the broader ambit of electoral reform. I think there are many questions that we have to address with respect to elections and the way they are conducted. So, not only the way candidates are able to contest election, but also other aspects which are in public domain. So, as a member of a political party, I would like to have a discussion, an all-party discussion on electoral reform inside public, under the rules that is available to us in Lok Sabha and Rajya Sabha, and let the public see that what ideas are different parties talking about when it comes to electoral reform, and specifically when it comes to the criminal background of a candidate. Secondly, as I said, in this particular case, um, of which I was a part of, I did support the decision of my political leadership that, when we, from a political analyst point of view, uh, the candidate that we chose not to give the ticket to was, in terms of winnability uh, and other aspects, had a very strong, favorable rating amongst the public, was very popular amongst his supporters and amongst the general public. But on the basis of this, we decided to not give him the ticket, and that's a decision I supported. And I think, again, within our party also, you know, when these conversations are had, usually at the time of election, because that's the time when we are looking at the background of candidates. I think, having been part of many screening committees, I'll continue to bring this information to public, or sorry, not to public, but make this information more transparent. So the criminal background should not be hidden or should not be diluted while we are discussing in a party platform. Thank you.
Can I ask you a question, Janatha?
Please, sir, go ahead, sir.
Yeah. Mr. Gogoi, you mentioned that one person was denied ticket because of his criminal background. Very good news. But I'm very curious to know what happened to the person you gave ticket to. Did he win or did you lose that seat?
As I told you, Qureshi ji, the person that we denied had very high approval rating amongst the voters, amongst the public, amongst his supporters, and we knew that we will put forward as an alternative someone with lower ratings, but we took that call and we lost the seat.
You lost the seat. Yeah. Okay. Thank you.
Would you take one more question, Mr. Gogoi, before you leave?
Yeah, maybe one last, and then I'll really have to leave.
Okay. Okay, Nandi, just one more question. This is from Mr. Dhruv Sen. Is this issue discussed in Parliament? If not, would you, Mr. Gogoi, like to initiate discussion in Lok Sabha?
No, I mean, I don't want to take any personal credit on this matter. I think all political parties are discussing electoral reform. I think institutions such as ADR are talking about electoral reform. Former election commissioners are commenting on this, writing about it. So, we're having this debate everywhere, but inside Parliament where it matters. I think we're having this debate inside political parties in our back rooms also when we discuss tickets. So definitely, I think this issue needs to be put forward in Parliament, as I said, under the broader ambit of electoral reform. It is, again, I must say, I myself I'm aware of ADR's work. We just last week referred to ADR's report on how many MLAs in Assam have cases related to harassment and molestation of women. So we did refer to the case, but I think, for a country, even for my Lok Sabha constituency of 18 to 19 lakhs, we don't need one ADR, we need many ADRs, and we need ADRs in many languages and in many formats. Thank you.
Thank you, Mr. Gogoi. Thank you very much. If any of the panelists wants to ask him something, because it's 3:30, he has to leave. Okay, Mr. Gogoi, thank you so much for joining.
Thank you.
And very nice of you to have spared the time and given your views. Thank you very much. I will now request Ms. Kavita Srivastav. She is the president of People's Union for Civil Liberties. She is a full-time human rights activist working to protect people's democratic and constitutional rights and to work towards justice in instances of violation of people's rights. Since 1994, Kavita has been promoting the formation of citizens' collectives to protect the civil liberties and democratic rights of every citizen. For 2 decades, she has been promoting collectively with other social groups non-violent ways of ensuring justice to survivors of atrocities committed due to gender, class, caste, religious group, or nationality. Her accomplishments include work with the women's movement in Rajasthan, which has initiated laws against widow burning and national guidelines against violence against women. Kavita ji, all yours.
Thank you so much, ADR, for inviting me. And thank you for posing these questions to a human rights organization and also one of the petitioners of the right to know, which came in 2003 with, every voter having the right to have the right to know what is the candidate's education levels, what is the candidate's wealth status, movable, immovable property, wife, family, etc., and also regarding criminality. However, there's been a dilemma right from the beginning regarding all these 3. For instance, even at that point of time, we had said that it's more important to know the education of the parents of the candidate, because education has taken years and years to reach people. And, it's even today, the number of Adivasi women or Adivasi men who are accessing education is still remains small, very small. So at that point of time, we had said that it's very important, this should be added in the form. Secondly, regarding criminality, even then there was a dilemma regarding, the system. What about dissenters? What about criminalization of dissent? And even at that point of time, we had said that how will the public distinguish between a case that is being put against you because you're a dissenter, and how will they realize that this is, can we actually discuss that this is a different case and this is a different case? So while you need to give some sort of leeway to this political opposition person, his case may be a false case. And so even at that point of time, we had questions regarding this, and it was debated amongst us. And I think later, the question whether at the charge sheet stage itself we need to disqualify people, that matter went up, to a constitutional bench. And the constitutional bench did not say that don't do it, said you could consider, and it remains there itself. However, our position in the PUCL has changed. Let me not say PUCL. A section of our organization would like to have some sort of, we want this collective, and particularly ADR. And let me tell you why ADR is very, very important for us, because we use all your reports. We don't have to do that work. We are all volunteers of the human rights movement, so we don't have staff, we don't have to go through those affidavits. Earlier we used to go through this. I remember preparing precisely on various criminality and others, some analysis, but now we get, because of you, and it's so good, right at the onset of the campaign, we do this press conference with you. I mean, all that is really, really good, and we use all your documents and go to the people, because ours is also going back to the people. We are not a political party, we are a minuscule, we are not a mass organization, we're a very, very small organization, but we do go to the people. So it also becomes very important, the documents you give us. However, there is this question that we now need to ask. And since we have people like Mr. Qureshi, and we have all of you who've been thinking, and parties representative who think day and night on this issue much more than us, is the weaponization of the criminal justice system against the not just the political opposition, but and not just dissenters, but all those who question. There is a weaponization of the criminal justice system. Whether an FIR will be lodged or not lodged, whether a charge sheet will happen or not happen, and whether the pace at which a trial will move, even that is extremely determined. It's because the police was always subservient. I mean, we had Prakash Singh Badal case where they wanted to liberate the police of the political system. It never happened. We had Prashant as one of our speakers. He was also a petitioner and intervener in it. There have been 8-9 reports. So the police was never independent. However, we still felt that, there was justice happening. I mean, I've worked with the criminal justice system for the last 30 years consistently, and I would still go with a lot of hope that something will happen. I mean, I wouldn't say the whole system in Rajasthan, at least, which is my Karam Bhumi, is totally vitiated. No, we used to get a lot of work done. We also thought that the administration would do fair inquiries or whatever. And the judiciary, we thought, maybe a third of our cases just get... there's a travesty of justice. I mean, we have all witnessed Bhavri Devi and all that. But today, I am really not sure, with the way the whole judiciary is also being weaponized against activists, and the police has become even more subservient, and the kind of campaign-led criminality that is determined by the media and social media campaigns against people. Can we just say that he is a prisoner of conscience, so you should vote him? She was a dissenter, so she had a case. I think it's getting more and more difficult. Even if, am I there? Am I audible?
Yes, we can
Major
hear you.
General Barma?
Yes,
Yeah. please
Madam, we
continue.
can hear you.
Yeah. So with a fair system, I mean, the kind of proposals you have brought up, like say, let's take the proposal of tainted. I think we all know the case against, I mean, I know Dr. Binayak Sen, the first case as dissenters, PUCL vice president, he was booked. I know he is completely innocent, but there has been a conviction, life sentence for sedition. Similarly, Umar Khalid, there's been 55 cases of murder of 55 people, 55 attempt to murder of 150 people. We know it's all rubbish. We know it, that the whole case is fabricated. However, will the taint ever come out? The taint remains in some, and the taint does not. We campaigned against Brij Bhushan Singh or Ateni, just in the last elections. So Brij Bhushan Singh, because there was so much of public outcry, they didn't give him. They gave his son, but he won the election. Everybody knows who won the election. So I feel, and I'm only, in order to highlight my case, I'm stating this, but the way minorities, particularly Muslims, are being criminalized, Adivasis, because it's become tooth and nail to protect your resources, and we are seeing a war at one level. So it's in this context that we have to look at criminality, which I mean, all of us work towards bringing wanting the public to know that, look at this is the crime that the person has committed. So as far as we are concerned, there are two things. One is that disclosure has to be absolute. You have to disclose. It's very good that we have it. But I don't think at this stage we can agree that ban the person 10 years, 15 years. I don't think we can. That will really, really be... I mean, George Fernandez was in jail and he fights and wins, and so many. I mean, look at Omar Rashid from Kashmir. And look at the other side, Rahul Gandhi. I wonder, I mean, I didn't hear the whole of Mr. Gogoi because there was a situation where I had to be in the first few minutes. I mean, Rahul Gandhi is convicted for a minor case in little time, even before he can appeal. The parliament procedure of revoking his membership and getting him to empty out his house also. It moved like this. Again, you will say, well, there will be exceptions, there will be some. But I think it's very important to understand how this system can be weaponized. I mean, what about Kejriwal? They came totally on an anti-corruption movement. And finally, Kejriwal goes to case on precisely, I mean, so some will go in corruption, some will go in sedition, somebody like Harsh Mandar. Every agency, I'm not saying he's going to fight elections, but they could use every agency against him, whether it's CBI, whether it's ED, whether it's IT. And finally, what they're going to do with it, we don't know. But definitely it won't be UAPA, we're very clear, or sedition. It's going to be corruption, So I feel we have to pause, Major General Verma. I think you people have to continuously ask us these questions. We cannot leave it hanging. It has to be there. And secondly, this question of yours, this question that you've posed to all of us, it's a public question now. I've already sort of posted these questions to everybody in PUCL, including Mr. Sanjay Parikh, who was the lawyer then with Justice Sachar. I said, answer this and give. The other question is that we as an organization have to take all of this to the people. And I think I just heard you say that what is the onus on the judiciary, on the executive? But when the judiciary and the executive doesn't listen to you, when the judiciary and executive is itself, I mean, we've seen bulldozer justice in a particular way. This is our context. And the judiciary never heard it. 5 years or 7 years later, they've taken cognizance. I think we need to take, like your reports, in a small way, we make parchas and take to the people. We have to take all these questions also to the people. I think you have posed these questions to the people of India. Tell us, are we going to continue with this? Are we, is the criminal rule, I mean, the lawbreaker being the lawmaker now? Who's the lawbreaker? That is the uljan I have. That's my dilemma, So I would try to conclude by saying that what you have initiated is a debate. You and I cannot, I mean, maybe you can answer. You all are into it on a daily basis. But or our organization, look at the larger context of human rights in order to understand our, defining and something especially like criminality. Like we always say in the civil liberties movement, that civil liberties is the bedrock of democracy. Secularism is the bedrock of democracy. Similarly, I think this push for honest legislators, this push for, we don't want bullies, we don't want murderers. But again, I'm talking with a certain question mark. Some of our friends there were false cases. So I end here by saying that these are larger questions that we have to pose to the public. You have initiated it in a small way. It should go into the parliament. It should go into all platforms which where democratic rights are being discussed. I mean, look at the hate speech. So again, so I conclude by saying that will we give more power to the state? It's the state power which is something that we are critical of. Will we give more power to the state to disqualify, qualify? I'm not even talking about the CEC, because at this point of time, CEC is merged in a way with the executive. CEC is not independent. That's something that we need to wrest CEC out of it. That should be a simultaneous kind of job that we need to do. So I
Kavita, we are
can
now,
make my points.
So you're muted. So you're muted.
yeah, I have to mute it myself. Am I audible now? Okay, thank you, Kavita, for your views. Very clear. But the dilemma still remains. If the judiciary is not going to do anything, if the executive is not going to do anything, and if the onus is entirely on the civil society organization, then we will never succeed, because for the simple reason, the public, the common people, as the politicians have said, they don't take criminality seriously. So where are we? Are we going to continue like this? And the question remains, one of the focus points, does this affect good governance?
It does. It absolutely does. I mean, I think corruption is a very, very good issue, but a very big issue. But the onus is on the public. In the public, we have to make the government accountable. We cannot keep adding more power to the state. We have to make state accountable, and that only the public can do. Parliament as an institution is almost over, and all these. So the public has a major role at this crossroad. The civil society brought these laws and gave it to the public, and we moved quite a bit, but at that point the context was slightly different. In today's context, the public really has to decide. I'm not saying civil society, our role is to take these questions, our role is to bring clarity, our role is to understand how it happened globally and share. There's a major role, but at the end of the day, the Indian public has to decide. Otherwise, there's not much that we can do.
Okay, thank you. Nandini, do we have any question for Kavita? We can take one before she leaves. Yeah, again, this is from Afreen. What are some of the countries you would like India to learn from human rights side of governance? What are some of the countries you would like India to learn from human rights side of governance?
So I think Scandinavian countries have had accountability systems. I think basically all those countries where you can make, ours is like colonial legacy, so we don't have accountability systems where we can make the state accountable. Like say for instance, RTI was a law which empowered the people against the state, and now that also we are losing. So all those countries, and I think some of the best examples are the Scandinavian countries. I remember going to Brazil just for this, looking at the governance on food issues. That is about a decade ago, and some very, very good systems that put in place as far as people's accountability was concerned. Not just the kind of policies and plans they had, but they had the kind of accountability that was worked towards. So in some element, I won't say every country is the best, but some systems in some countries we need to learn from. South Africa also we need to learn. So these are some of the things, but in our country, I feel we did learn from other countries. We need to, say for instance, bring in the accountability law, something that the Rajasthan civil society groups have been, for the last 10 years, we have been taking this, that this is part 2 of RTI. We need the accountability law for all platforms of governance. And it's only accountability, those governance systems we need to bring in. It's not just that you have a model citizen, our people are not even enabled to become citizens. When women have agency and they start taking decisions, the state say, for instance, the right to choice, and she is expressing her autonomy through her citizenship and wants to marry somebody of her choice, we know how heavily the police and the executive comes in to assist the family to prevent all that. We keep hearing about it every day. So it's also a struggle to become citizen. So kind of governance in which I get these platforms to ask questions, to make accountable. Those are some of the questions that we have to ask. There is no shortcut, Major General Verma. This criminality cannot be done through laws. We have to work very hard with the people. That's something that I'd like to say. And we have done it. I mean, it's not that we've not done it.
Thank you, Kavitaji. Thank you so much. She's involved in some very important issue. She's sitting with some lawyers to sort that out. So she has also requested to be relieved now. Kavitaji, thank you very much for your views. And
Thank you, and we are your partners in this. Please
Thank you
take
very
us
much.
along with you. Thank you. Thank you, Mr. Qureshi.
Thank
I'm
you very
sorry. I'll hear you on YouTube and other speakers.
Thank you very much. Thank you. I'll now request Dr. Qureshi. He needs no introduction. We all know he was the 17th Chief Election Commissioner of India, the world's largest democracy. And he has also figured in the Indian Express list of the 100 most powerful Indians of 2011 and 2012. He has authored a monumental book, An Undocumented Wonder, The Making of the Great Indian Election, and has also compiled and edited the book, The Great March of Democracy, 7 Decades of India's Elections, among other books. Sir, with that very brief introduction, I would invite you to kindly share your views.
Yeah, thank you, General Verma. Thank you for inviting me, and thank you for taking up this very important topic for a webinar. I was hearing the two speakers before me. They spoke very well, added to my knowledge. I'll only say 2-3 things. Let me also put on my clock so that I'm within 30 minutes. This issue has been hanging fire for good 30-40 years, and there seems to be no solution. We are going on and on, more or less saying the same thing, almost moving in circles, which is a pity. Secondly, what you pointed out in your opening remarks, the problem is, despite all the debate and all the concern which everybody expresses, including the political party, which is amounts to only lip service, the problem has only been increasing. You read out statistics from 2004 election to 2024 election. It has gone up more than 100%, 125% or so. So the problem is on the increase, and for this reason, any solution coming from Parliament is becoming a remoter and remoter possibility, because these are the guys whose fate we are going to decide, and they are the guys who are going to make the law. So, which is an unfortunate thing. Then we have been demanding that Election Commission's proposal has been that don't wait for the conviction. Although currently there is a debate that after somebody is convicted, will he or she be banned for life? Which of course I oppose, because life sentence and life punishment for offenses like this may be too much, but already the law which exists, that you serve 2 years sentence, 3 years sentence, and after that 6 years of disqualification. So 9-10 years is enough for a politician to be out of sight and lose his or her relevance. So that is punishment enough, and I'm against life imprisonment. That is, too much, asking for too much. When we can't get this, we're asking for 100 times more. That's not going to work. Thirdly, the winnability, the issue over integrity, that is something which I have also been talking about, and in my book, which you mentioned into Undocumented Wonder 2014, I had mentioned that if only political parties try, this principle stands that we will not give tickets to a criminally tainted candidate. People will rush to vote for such a party. I was proved wrong. I'm very sad and sorry that this turned out to be a misjudgment. I thought the people will support this stand. And at one stage, I remember in 2012 and 13, Mayawati had asserted that she's not going to give tickets to criminal candidate, but she did. So, and I had in my book, that was the context in which I appreciated that this is a very good stand and is likely to win people's support. He did not. In fact, I remember reading a paper. I think one of the writers was Mr. Ishwaran from Bangalore, and one more person I've forgotten, but I'll try, or maybe General Verma can remind me, where the detailed study showed that the criminals and the rich people have greater chance of winning elections. Their winnability is higher. And so even a research study has proved that. Therefore, I think, and then Mr. Gogoi's anecdote of his own party, his experiment when they tried to follow this principle and lost that seat. Now, for a political party, winning every seat at whatever cost is absolutely important. We should realize that. Because if they lose and sit at home, what use is that principled politics? So first thing is for them to win election. So therefore, this debate between winnability and integrity is almost clinched as far as I'm concerned. Now the judiciary, keep talking about judiciary's role. There are two possibilities. One is they set up special courts only for this purpose. The other is ask the existing courts to expedite the cases of the politicians. The argument against the latter thing is that how can the court give preference to a particular kind of cases? Although I mentioned in some of my articles, it's not true. The existing courts have been prioritizing. They can give priority as a matter of policy. But okay, even then, the other alternative of setting up a special court, well, Supreme Court has finally done it in 2018 when they asked all the state governments to set up a special courts. And I think 11, how many states, I'll just tell you the figures, that 11 states or 12 states have set up these courts, but that is perhaps not enough, and the performance of different states varies. So we have to do something about that. In 2021, Supreme Court reviewed the performance of these special courts and expressed its dissatisfaction because the number of cases disposed was not as much as was expected, and so on. So, but we know very little about this. The fact that the special courts were set up, Supreme Court did monitor, expressed the dissatisfaction. I've not seen it in the media. I just researched there, and in that I found out. I would recommend to General Verma and ADR or PUCL and other civil society organizations to why not kindly do a quick study. Just collect the data is not a very complex study. What has been the performance, what has been the experience of these special courts, and how to take it forward. Then passing it on to the voters again makes me very uncomfortable, but the fact is that the voters can be brainwashed. And one example is that after COVID, when people walked 1,000 kilometers, lost jobs, hundreds of them were killed. After demonetization, when hundreds of people were died standing in the queue, immediately after that, when there were elections, the government which inflicted these atrocities won hands down. Now, it was surprising. And my cynical analysis is if you ask a voter in Bihar, do you want a job or do you want the head of a particular community's person? Their jawab will be कि no, job तो मिलती रहेगी, बाद में मिल जाएगी, लेकिन हमें फलां का सर ला दो और ये तो फलां लीडर ही कर सकता है. This kind of response, and this is what is getting reflected in the election. In such a situation, don't vote for a criminal candidate. Do you think this is going to have any impact? Zero. And as was mentioned by the previous year, particularly Kavita Srivastav, that wrestling federation chief, despite the molestation of women, and not one, two, three, but so many and all champions, he continued to enjoy the protection of the political party, gave ticket to his son, and he won hands down. Again, what can we expect from the people? Therefore, again, it sounds cynical, but then just as politicians brainwash the voters, civil society and the media and all of us together also must have a counter program to, I would not use the word brainwash, but to also to educate them to think correctly and behave appropriately. Then, you know, finally, I would like to mention one dilemma which we have been facing, that when we say election commission suggests that people against whom serious cases of criminal nature are pending, during pendency they should be debarred from voting. There has been a great debate on it. A law commission considered the issue. It has gone to the Supreme Court. They all say that the law of the land is the presumption of innocence. You are innocent till proved guilty. Fair enough. But I have been asking a counter question even in conferences when judges of the Supreme Court and High Court, they were sitting, very senior jurists were sitting, and I asked them the question and there was complete silence. Till today, I have not got a reply. And what is my question? Okay, look, you all talk of presumption of innocence, and we know it very well. But in Indian jails today, there are 431,000 prisoners, of which 71% are under trial. That means not yet convicted. That means innocent. But although they're innocent by your own definition, but you have taken away not one or two, but four fundamental rights: right to liberty, freedom of movement, freedom of occupation, right to dignity. Four fundamental rights you have taken away of 370,000 innocent people. What is this? Explain to us the law. If you can take away four fundamental rights of an innocent person, what is the big deal about taking away his right to contest? It's not even a fundamental right. It is a statutory right which can be suspended for some time. And if it is suspended, you will notice that the same people will rush to the court and get the best lawyers to get their cases expedited rather than delayed. For 20 years, the case goes on and the rapist continues to rape. So what is this? Therefore, I'm surprised that despite our very mature democracy, very mature judiciary, they have not been able to find a solution, and the impact is for everybody to see. So I think these are some of the remarks I have. The role of election, the ADR comes into the picture again. You only can play the role. The fact that we have such seminars, the fact that media mentions how many criminal MLAs, MPs have criminal cases, it's only because you are pointing it out. The fact that even the courts have said that every political party should advertise how many criminal candidates they put up and what are the cases. The fact that candidates themselves are asked to publish along with their promotional advertisement that these are the cases pending against me. All that is a very positive outcome of this debate, of which ADR, of course, is the institution which is playing the key role, for which you deserve compliment, General Verma. Thank you very much.
Well, thank you, Dr. Qureshi. If you would be here for some time, sir, can we take the questions at the end?
Yes,
Thank
of
you.
course.
So now I'll invite Mr. Ruben. Mr. Ruben is a lawyer, technologist, socio-political activist, and is the National Joint Secretary of Aam Aadmi Party. He is the spokesperson, working president of the Mumbai unit. He is also the co-founder and director of Khana Chahiye Foundation, which works towards solving for hunger in urban India through policy advocacy, use of smart technology, and community mobilization. In 2009, as part of his Jago Re campaign, Rubin registered lakhs of first-time voters in Mumbai. In 2011, he was at the forefront of the India Against Corruption movement, and he also launched the Zero Tolerance Campaign, ZTC, successfully, amending the anti-sexual harassment law in Maharashtra, making it stronger and pro-women. He's a digital evangelist. He was awarded the prestigious title of Mumbai Heroes by Mumbai Mirror for contributing to the highest ever voter turnout in Mumbai in 2017 by partnering with various state election commissions. He is presently practicing law as a counsel at Samya Partners at Mumbai High Court. Over to you, Ruben.
Thank you so much, General Anil Verma. It's an absolute honor to be invited to this esteemed panel with the likes of Qureshi Saab and Prashant ji, whom all of us look forward to. So thank you so much for this. And I'd like to congratulate you for actually taking such a complex and a difficult topic, which doesn't really have a straight answer. And we require more of these discussions. First, I think I'll just make my opening remarks, and then I'll try and answer those questions of the webinar to be specific. And then maybe we can open the floor to questions and answers. First is, why do criminals enter politics? Criminals enter politics because our political system gives them ample opportunity to subvert the criminal justice system. We do not have independence of investigation. We know as soon as an accused jumps to a particular political party, we have the cases against them going slow. We have, in some cases, summaries being filed against them as though there is no case that is being made out by the prosecution itself. So all of this happens because this is a systemic problem, and this is a very deep problem. And when we speak about this issue, we shouldn't look at it in terms of a binary, whether it is just a criminal or a non-criminal, or for that matter, the way politics looks at it, are you with a political party or you are not with a political party? So let's look at politics and then come to the issue at hand. In Parliament, dissent is equal to defection. There is no place for nuance. As soon as there is a whip, and if somebody votes against the whip, the person is there is anti-defection proceedings which are initiated against that person. So when you have such an arrangement, you don't have politicians who are committed to party ideology. You have politicians who are committed to one particular person or the party without any commitment to a party, political ideology. And if you have such people coming into politics, then what can we really expect of them? Now, let me speak about this entire criminal and non-criminal debate. I think there has to be a distinction that is being made in terms of a person who is accused of a crime and a person who's actually undergoing a trial and a person who's actually convicted. Let me give an example. I was protesting in Mumbai against the arrest of my leader, Arvind Kejriwal, with what is clearly weaponization of the criminal justice system in terms of political vendetta. And we protested, we burnt an effigy of Prime Minister Modi. And just for that act of protest, I have a case of arson and rioting against me and my fellow colleagues. And it's very easy for the criminal elements to file a case against the non-criminal elements to make them look criminal. So the way I look at it is when we see the kind of discourse that we have in politics, I think people just don't have a choice. And the reason why people vote in a particular way is because we have the first past the post system. And in the first past the post system, nobody wants to vote in such a way that their vote is wasted. So irrespective of whatever choices are given to them, they just go with that because they don't want to vote for a candidate who is losing. Having said that, there is a lot of discussion about winnability. And while winnability is important, yes, as a political party, you are essentially pursuing power. What is really missing is this representability. Is this person good enough to actually represent me or represent my aspirations in Parliament or in the House or anywhere where the person is essentially elected? And the problem is far more complex because even if you let's say disqualify a particular person, like in the case of Brij Bhushan, you actually had a proxy in case of his son, and this is a multiple-headed hydra, which really needs reform. But of course, more than anything else is political pressure. So there was a discussion in where Mr. Gogoi, prior to me, said that there is public pressure. There is public pressure. It's not that there is no public pressure. There is enough and more public pressure. What is needed is for the culture to be set at the top. What is needed for political parties to actually give tickets to decent people. But of late, what we've been seeing is this extremely dangerous trend where, as Kavita ji rightly mentioned, that the criminal justice system is being weaponized specifically against the opposition. We see cases of vendetta. We see how it is only systematically that the opposition is targeted in state after state. It's part of the BJP's playbook. It is that Kichad uchalo aur uchalo kuch to chipkega. And it is that narrative management that, okay, there is a case which is basically against you, and hence you are as criminal as somebody who is convicted. So that distinction has to be made, and that distinction is extremely critical. Having said that, I will now go on to specific questions which were part of the webinar. First is, who will bell the cat, executive or the judiciary? It has to be the judiciary in this case, because the executive is just an extension of the legislature. There is no distinction between the executive and the legislature. It is sad, but it's true. You expect your elected representative to actually be the executive in your area. It's not that the elected representative just focuses on making laws. And obviously, we all know that most political parties asking them to do something like this is basically trying to get turkeys to vote for Christmas. So it has to be the judiciary, because the judiciary has taken the vow of upholding the constitution. Second, does it impact good governance? I think it certainly does impact good governance. When you basically have such criminal elements in office, all that they are interested in is not issues of public importance. It's not issues of governance. It's essentially self-serving. And of course, governance suffers. Governance as a good of public service delivery also suffers. Should there be a lifetime ban or disqualification? I think the very fact that somebody is penalized, and if a person is disqualified, I think a person should be disqualified for a particular period of time. And there can be consensus in the parties, right, with regards to whom should the tickets be given. But I think this lifetime ban is something which is without precedent anywhere in the world. And I think the disqualification, and as long as a person has served the sentence, especially in a reformative system like ours, we should go with disqualification. With regards to reforms, will reforms actually work? I think any reform is dependent on the weakest link in its reforms. If we actually look at the lower judiciary, it is an absolute shambles. As a practicing lawyer, I'd like to stick my neck out and say, and sadly say that the pursuit of justice is a luxury in our country. And given the painstakingly slow process and the quality of justice that we have in the country, there is much more that needs to be done. Because right now, what we're seeing is actually institutional erosion. Because let's say that if you actually had such a pronouncement from an institution which was absolutely beyond reproach, it would have been great. But with regards to what happened with Justice Verma and the notes and the cover up and what is happening and what is not happening has also resulted into a lot of erosion of institutional integrity. So having said that, I think there is a way forward, and the way forward has to be that political parties set this culture. And whoever said that politics is the last resort of the scoundrel has done the greatest disservice to humanity. Politics is for the brightest. Politics is the most efficient tool to bring about social change. And having said that, it is about this new political culture where criminal elements are not supported. And I think young people in the country who make up over 70% of our population and our electorate, at least for the next 20 years, will be fairly young. I think that group of constituency, that young people will essentially put this pressure on the demand side so that we actually don't need a supply of criminal politicians. Thank you. Thank you so much.
Thank you, Ruben. We'll take the questions in the end.
Sure.
I'll now invite Mr. Prashant Bhushan, who's been waiting patiently. Thank you for joining, sir. And we all know that he's one of India's most well-known and respected public interest lawyers and a human rights activist. He has been practicing in the Supreme Court of India and Delhi High Court for the last 3 decades. He was a member of the faction of the India Against Corruption movement known as Team Anna, which supported Anna Hazare's campaign for the implementation of the Jan Lokpal bill. He is the author of The Case That Shook India and Bofors, The Selling of a Nation. He is associated with various organizations, including the Center for Public Interest Litigation, CPIL, the People's Union for Civil Liberties, PUCL, and Transparency International India. He is also the convener of Judicial Accountability and Judicial Reform Campaign Working Committee. He has taken about more than 500 pro bono cases that deal with environment, corruption, electoral reforms, etc., and much more. With that brief introduction, I would like to now invite Mr. Prashant Bhushan to share his views.
Thank you, General Verma. While this is certainly a very important issue for us to think about as to why there are so many criminals in politics and who are successful in politics. As Mr. Qureshi told you, that there is one proposal that has been made from time to time to deal with this problem, which is that those who have been charge sheeted or those against whom charges have been framed, those politicians, they should not be allowed to contest, because we can't wait till their conviction, which often happens after many, many years, because they can delay the proceedings. The problem with that suggestion is the following. You see, charge sheet is in the hands of the investigating agency, which we have seen is in the hands of the government, notwithstanding the Supreme Court's orders on police reforms and reforms of the CBI, etc. Despite that, we are seeing that these investigating agencies act largely at the behest of the ruling party, who control them. And it is easy for them to just frame any opposition politician if they want to, falsely frame them. And if they frame them falsely, for example, I'll just give you an example. Let's say that an opposition politician is accused of rape, and they get somebody, a victim, to say that yes, he raped me. Now, obviously, if a police files a charge sheet on the basis of the allegation of that victim, then the court will have no option but to frame charges and hold a trial. So that would mean that till the trial is completed, this politician would be barred from contesting the elections. So therefore, such a provision can lead to a lot of misuse by the ruling party against opposition politicians who may be wrongly framed, and courts have no option but to frame charges, because at the stage of framing charges they cannot judge whether the statement or the allegation made by the victim is true or false. And therefore that was found to be quite dangerous, and therefore it was felt that the present provision, which says that you are barred only after conviction if there is no stay of your conviction, that provision should continue. Now, you see, it is true that there is a big problem because politicians are able to, important, powerful politicians are able to delay their trial for a long time and thereby prevent their conviction. Very often, in a delayed trial, witnesses also turn hostile. They are able to influence the witnesses, etc. This is primarily a failure of our criminal justice system. Sometimes they are able to delay the investigation itself for a long time. Sometimes even FIRs are not registered and so on. So, unfortunately, to some extent, this is the result of the non-implementation of the police reforms which were ordered by the Supreme Court. One of the reforms was to separate the investigation wing of the police from the law and order wing, because the basis was that law and order is an executive function, government can be in charge of that. But so far as investigation is concerned, that is part of the criminal administration of justice. And therefore, that need not be under government control, or certainly can be much more insulated from government. And unfortunately, none of that has happened. There was a direction regarding the manner in which DGPs should be appointed, that UPSC should select 3 names and the government only has an option to select one of those 3, etc. But even that has not happened, and we are seeing that even UPSC's independence has collapsed in recent times. And therefore, Mr. Prakash Singh has made another application for modifying this and having a selection committee for DGPs, just like they have for the CBI director, that is Prime Minister, Leader of Opposition, and the Chief Justice of India. So there is a problem at the level of investigation. There is also a problem at the level of trials. So in that, the reason is that the whole judicial system has collapsed and trials take interminably long. Sometimes they take 20 years, 25 years, etc. And therefore, for that, we need to reform the criminal justice system. In fact, just yesterday, there was a case in the Supreme Court which was filed by us in 2004 by one lawyer called Mr. V.K. Hori. And the prayer in that petition was that the investigations and the trials of powerful people, and powerful people needed to be defined, and we had attempted a definition of powerful people, who are key players in our democracy, should be fast-tracked and should be supervised or overseen by the high courts, etc. That both the investigation as well as the trial of influential people should be fast-tracked and overseen by the high court. This is the suggestion. That case has been still pending. It is adjourned. And of course, one option is then the court asked the law commission to examine this proposal, etc. The law commission gave a very detailed report, and the law commission's report was largely for strengthening the entire administration of justice, of criminal justice, and for speeding up all trials, not just of influential people. Now, judicial reforms is an area which has been pending consideration or really hanging fire for a very, very long time. For many years, for the last 40 years, law commissions have made repeated recommendations that we need to increase the number of judges. Our number of judges is very low. But far from doing that, we have not even succeeded in filling up the vacancies that are of the posts which are already there, of judges both in the lower courts as well as in the high courts. There is roughly 30% vacancy in the lower courts as well as in the high courts on an average across the country. So law commission has been saying we need to increase the strength of judges fivefold. Far from fivefold, we are still functioning at only 66 or 70% of the strength of the existing judiciary. Then we made a Gram Nyayalaya Act in 2010 or so. Until now, we have not implemented that Gram Nyayalaya Act. The idea was that at least ordinary petty cases could be disposed of in these Gram Nyayalayas, which would be like courts, but more informal courts, which would be set up at the sub-tehsil level. Today, we have civil courts only at the tehsil level. Unfortunately, even that has not been implemented. So we are seeing across the board a failure on the part of the political class and also on the part of the judiciary in implementing judicial reforms which would bring about a quicker administration of justice. And today, after this Justice Yashwant Verma affair, the whole attempt of the government only is to somehow seize control, use this case to seize control of the power of appointments from the judiciary. Of course, there are many problems with the present system, collegium system of selection. There is no transparency, there is a lot of nepotism, etc. But in the collegium, and those problems would remain even if the executive were to get some more control of the judiciary. But at least in the collegium system, somewhat more independent judges are being selected as compared to the system where the government has more say in the manner of appointment of judges. What this government has been doing for the last 10 years is it has been stopping the appointment of independent and competent judges by just sitting on the recommendations of such judges by the collegium and only issuing notifications for the appointment of those judges that this government likes. And and then they are able to sometimes strike a compromise with the collegium and they say, all right, you appoint two of our people, then we will appoint one of the people that you have recommended, etc. So it has become a serious problem. But we need to implement across the board judicial reforms for a quicker decision in all these cases and therefore quicker conviction of those who have actually committed crimes and quicker acquittal of those who are innocent. Because even that is important, that if somebody is innocent, he should be quickly acquitted and that case should not remain hanging for so long. Then we have this phenomenon which Mr. Qureshi also mentioned, that unfortunately, despite the people knowing with this ADR judgment, the criminal records of the candidates come to be known. But yet, criminals are often elected by the people. Why is that happening? That is happening because our whole system of electoral politics and elections has become a game of money. And it has become a game of money because we have first passed the post at two levels. When we select the candidate at the constituency level, the candidate who gets the highest votes becomes the sole representative of the constituency, even if he gets only 25-30% of the vote. If nobody else has got more votes than him, he becomes the sole representative. Then when the government is formed, the party which gets a majority or the coalition which gets a majority becomes the sole government, and the opposition, even if it has 49% of the seats, counts for nothing in running the government. Therefore, when people go to vote, they are not necessarily voting for their best candidate or party if they feel that their best candidate or party has no hope of winning. Now, how do they assess who has some hope of winning or has no hope of winning? That assessment is made on the basis of visibility of the candidates and the parties. And visibility is essentially a function of money. If you have money, you can buy advertisements in newspapers, TV, you can put hoardings, you can have your paid workers going around with your posters, handbills, etc. You can even organize large political rallies on the basis of money. So therefore, only those parties, apart from few exceptions, by and large, only those parties which have a lot of money are able to give an impression to the voters that this party may win, because this party enjoys a lot of visibility. Now, to deal with this problem of spending too much money, a law was brought to put a limit on the spending of candidates. There is a limit of 95 lakhs or 1 crore for Lok Sabha candidates, etc. But firstly, that limit is not enforced because people sometimes spend 50 crores on elections. They spend all the money in cash, and the election commission is unable to catch them or unwilling to catch them. If they happen to be of the ruling party, election commission in the last few years, as we have seen, has become a puppet of the government. And they are unwilling, not wanting to catch people of the ruling party, even if they have spent 50 crores. However, they sometimes may be unable to catch them because they can't really get evidence of this person spending 50 crores because he has spent most of the money in cash, and he declares in his election return that he has only spent 70 lakhs or whatever, 75 lakhs in his election. Now, this could have been controlled if the government had implemented notebandi for at least political parties and the candidates. That means they should have said, when the Prime Minister went for demonetization, he said that, look, I want a cashless society. Now, I can understand that ordinary people can't be cashless, but at least political parties and candidates can be made cashless. You just pass a one-line law, make one amendment to the Representation of People Act, which says it shall be a corrupt practice for a candidate to spend or take any money in cash, period. That will be a corrupt practice for which they will be liable to be disqualified. Now, if you are caught, even in one instance, of spending any money in cash or taking any money in cash, you will be disqualified. If this law had been brought, it would have curbed this thing to a very large extent. Secondly, there is no limit on spending by a political party. Now, if the BJP puts up 500 candidates in the Lok Sabha, at most, all the candidates of the party put together can spend 500 crores. But the BJP in the last 5 years gathered 16,000 crores just by way of electoral bonds as well as other donations. Where is 500 crores and where is 16,000 crores? That means the party can spend 30 times of what the candidate can spend on the elections. There is no limit on the spending by political party, etc. So therefore, we have reduced what Anna Hazare said. We have reduced elections to a game of paise se satta or phir satta se paisa. After you get elected, you use your power to get more money, and this is what we have come to. Of course, to curb the influence of black money or curb the influence of money in elections, we can implement several other reforms in our electoral system. One of them is proportional representation. In proportional representation, if a party gets 2% vote only nationally, it will still get 2% people elected. That means 11 people will be elected to the Lok Sabha of that party, even if it gets 2% vote. Then I know that even if I am voting for a small party, if that's the party that I like, I am not wasting my vote. Then I will vote for the party that I really like rather than in this first part, the post, where I will feel that, look, this party is not going to win, I'll be wasting my vote. And therefore, I will vote for the less bad among the two parties who have some chance of winning. This is what is happening. So therefore, proportional representation, then state funding of elections. So there are many candidates or many parties who don't have any money, even not even 1 crore per candidate. So therefore, their candidate cannot even spend 10 lakhs, what to say of 1 crore in the elections. Now, to get over that problem, a proposal was made that you have state funding of elections, which means that every candidate who contests the election, after the election is over, will get, let's say, 50 rupees per vote that he has received. So if he gets 1 lakh vote, he gets 50 lakhs. If he has received 2 lakhs votes, he gets 1 crore. Now, this way, he can take loans from his friends, etc., friends and relatives before the election to contest the election, and then repay them after the elections by getting that money. Those who say that, no, this is too expensive, don't know what they are talking about. 50 rupees per vote only means there are only 60 crore votes which are cast in a general election. It means 3,000 crores, which is peanuts. 3,000 crores for the state to spend by way of state funding of elections is peanuts. And you can put a limit that those people will not get more than 1 crore. That means if you've got more than 2 lakh votes, the maximum that you will get is that 1 crore, which means that you won't even spend 3,000 crores, you'll probably spend 1,500 crores. This is an easy thing to implement, but obviously those who are in power, they don't want to do this because they have all the advantage of power. BJP has 30 times as much money as the next political party, 30 times. Now, obviously, BJP will not like to curb if they are in power, they will not like to curb the role of money power in elections, etc. And that is why these political reforms are not being implemented. Therefore, we need to have very, very clear, strong electoral reforms, strong judicial reforms, strong police reforms, if you want to curb this business of preventing criminals from getting elected, etc. Thank you. General Verma, I won't be able to stay till the questions because I have to go somewhere. There are people who are waiting in my office.
Okay.
So, are the questions right now or will they be after some time?
Thank you so much for your very wide-ranging comments on. I think you covered almost all the issues which are ailing our system, be it the money power or the muscle power or the system of voting, first past the post, etc. I just want to raise one question to you and to Dr. Qureshi. As per the 170th and the 244th Law Commission report, as also the J.S. Verma Committee report, they had recommended that at the stage of charges frame, a person should be disqualified. What are your views on that?
No, I told you what my views are. They are very clear. That would be dangerous because, see, the court has no option but to frame charges. The court cannot go into the correctness of the evidence which is produced by a police officer. If the police officer wants to frame an innocent person, then all that he has to do is to put the name of one witness in 161 statement saying that he saw this crime being committed. If it's a rape victim, the rape victim or somebody else who says, no, I saw this person being raped. If it's a murder case, just one witness, 161 statement, maybe a false statement saying that I saw this person murdering. The court in such circumstances will have no option but to frame charges. And therefore, it will be easy for the ruling party who controls the police machinery to disqualify opposition candidates that they fear by just framing them in this way. And that is why this was not eventually accepted.
May I come in on this, General Verma?
Please, boliye.
Yes, sir. Please, sir.
Mr. Prashant Bhushan has very correctly pointed out the risk involved in, the framing of charges, because it is true that charges are framed by the police totally on the basis of the orders of the political masters. So there is no fairness. But judicially, I had conversation with some judges of the Supreme Court at different points in time. One very senior judge of the Supreme Court said that the framing of the charges, the judge can throw out the charges. And he says there are lots of cases which come in appeal that the charges have been framed wrongly and they go into appeal. Therefore, maybe theoretically that is the case, that the framing of charges has to be with the application of some judicial mind. Many other people say that, as Prashantji was saying, that it is almost automatic. Whatever police says, the court says, yes, these are the charges. So, but he knows better.
What I was saying was that it is true that the court has the option of throwing out the charges, but that is if the charges are absurd and not supported by any evidence. Suppose somebody says that, look, this person has committed this murder, he is charged, the charge sheet is filed for murder. And the only evidence that the police produces is that somebody said that, look, I saw him walking past this dead body. Then the court will say, look, this is no evidence to charge him or accuse him for murder, and therefore he is discharged. But if the police is clever enough to say that some eyewitness is saying that I saw him shooting this man or whatever, then charges will have to be framed, because at that stage, the court cannot go into the correctness of the statement of this witness. That's what I was saying.
Okay.
Thank you. Thank you so much. So we'll take one or two questions because we've already overshot the time. Mr. Bhushan, thank you very much.
Thank you, sir. Thank you.
Thank you very much. Nandini, just one or two questions. Question for Mr. Reuben. What would the route look like for the judiciary to pass reform in the legislation? Who would enforce this? Would this process languish in the judiciary for years? This is from Mr. Srikanth Narayanan.
So, quickly, see, I think if the judiciary can just function on its, as far as its sanction strength is concerned, which Mr. Prashant Bhushan just alluded to, that in itself would make the criminal justice system much more faster, much more efficient. But having said that, as I said, that this is more of a political culture problem, and as we rightly discussed, this needs deeper electoral reforms, deeper political reforms, and deeper police reforms. So I think multiple things need to be done with regards to that. But more than anything else, it's about the political parties themselves essentially owning up.
Thank you, Reuben. Nandini, one more question, if there is any. No other question? Dr. Qureshi, final words, if you would like to say something.
No. I have nothing more to add, because you had a good range of speakers, and all of us put across different aspects of the same problem. And of course, I wish there was more public participation, but it doesn't matter. It is going to be on record. It will be available on YouTube. People can see these views. But at least discussion on the subject is important, and that is the important job which you're doing. Solution is not easy. It is very complex, as Prashant Bhushan ji also pointed out. Don't know what is the solution, but one solution which at least Supreme Court tried to attempt about setting up the special courts. As I requested, I am repeating and reiterating, kindly get that studied, or ask CSDS or whosoever, or maybe consortium of VP 11 state, 12 state, exactly what has been the experience. Let us understand. So of course, Supreme Court has also asked it to be studied, but you can also do the study. What has been happening? It 2018 and 20. It's almost 7 years. So that at least that will give us some direction, some light for the future. Otherwise, thank you so much. It was very nice and very stimulating. Thank you.
Thank you very much, Dr. Qureshi, Dr. Ruben, Advocate Ruben, and Prashant Bhushanji, Kavita, and of course, Mr. Gogoi, who already left, and to all the participants and the viewers who are watching this and giving good comments. And because of shortage of time, we couldn't take up all the questions. For that, we are sorry. Thank you very much for being part of this discussion. Namaskar.